May it please the court. My name is Simon Pena.
My name is Mahak Merchant.
And we represent the petitioner, Timothy Ivory Carpenter, in the case before the court today. We will be addressing the warrantless search and seizure of cell phone records, including location information data, over the course of 127 days, does violate the Fourth Amendment to the United States Constitution. Will the court benefit from a brief recitation of the facts?
Yes, thank you.
4 men, including the petitioner, were arrested in connection with a series of armed robberies. One of the alleged conspirators gave the phone numbers of all of the other participants, as well as his own, without the knowledge or consent of the people to whom those phone numbers belonged to. The police then obtained transactional records, without a warrant, including but not limited to the phone numbers dialed and calls received, as well as the cell site location information data.
Counselor, is your motion to suppress limited to the CSLI data, or does it include all these other papers as well?
Your Honor, this court, in ruling in either of those ways, will be ruling in favor of Mr. Carpenter. However, one of the arguments that we will be making is that the Stored Communications Act in and of itself was unconstitutional. And as the Stored Communications Act was the basis for the police officers obtaining the information from the cell phone company, that would make each of the pieces of information obtained through the Stored Communications Act unconstitutional.
Thank you.
This cell site location information data spanned over 127 days, which the government relied on when charging the petitioner, Timothy Carpenter, with aiding and abetting robbery that affected interstate commerce in violation of the Hobbs Act.
How does the duration of that search impact its constitutional validity, Counselor?
Your Honor, the duration of the search goes toward the invasiveness of the search, since over the course of those 127 days, the FBI collected more than 12,000 points of data for Mr. Carpenter's CSLI.
In our time before the court today, we will be addressing that 1, there was both a search and seizure of Mr. Carpenter's papers and effects. 2, the Stored Communications Act does not fulfill the warrant requirement to the Fourth Amendment. And 3, that the third-party doctrine is not applicable in today's case. Each of these issues would allow for a ruling in favor of Mr. Carpenter in the case before the court today.
The first issue addressed in this brief is whether or not there was a search of any person's, house's, papers, and effects. In this day and age, technology has become an appendage to American society. Unfettered, this would enable the federal government to easily track most of the American population.
Counselor, how has modern technology impacted our view of what constitutes a search and seizure?
With the development of modern technology, the Fourth Amendment and how we apply it has developed with it. The Fourth Amendment has adapted to move from the idea that was stated in Katz with the ruling on the Fourth Amendment that a invasion of a person's personal property and the physical invasion of their personal property is the only thing that violates a Fourth Amendment. Violates the Fourth Amendment. Now we have moved to a standard that says that if there is a reasonable expectation of privacy, an invasion of that expectation of privacy is what violates the Fourth Amendment, not the invasion of a personal property.
Fortunately, this court has established a strong defense against such invasions of privacy. For example, in United States v. Jones, the government installed a GPS tracker on Jones's car, which then proceeded to document the location of Jones for a month. This court held that due to the length and invasive nature of the GPS tracking, it was considered to be a warrantless and unconstitutional search under the Fourth Amendment.
Yes, but in that case we were dealing with GPS data, and in this case we're dealing with CSLI data, which doesn't track your location with the exactitude that GPS does. Is there a constitutional difference in those two types of data?
Your Honor, although they are inherently different, the court should not view them as different, because they both do track people without their consent. And if this court does allow CSLI data to be searched without a warrant, it's creating a precedent for the future that as CSLI data adapts to the new technology, it makes it more precise in the future.
And Your Honor, in Jones, not only was there a violation of a physical violation of Mr. Jones's property, but there was also a violation of his expectation of privacy, and that is the standard we are using in today's case.
Okay.
In today's case, the federal government has again violated a right to privacy. Specifically, the government failed to obtain a legitimate search warrant, and instead attempted to surpass the warrant requirement by insufficiently using a court order for disclosure under the Stored Communications Act. There was no search warrant in Jones, and there is no search warrant in this case either. Due to the fact that the government attempted to surpass the Fourth Amendment by using the Stored Communications Act, they failed to acquire anything to indicate an oath, affirmation, or trustworthy source. And the Massachusetts Declaration of Rights even stated that all warrants therefore are contrary to this right, if the cause or foundation of them not be previously supported by oath or affirmation.
Counselor, are you saying that in order for the Stored Communications Act to be constitutional, then it has to have an oath or affirmation requirement, or just for an instance of a search to be constitutional, that the order that led to that search must have been supported by an oath or affirmation?
Your Honor, we believe that both need to have an oath or affirmation in order for it not to violate the Fourth Amendment. Because in the writing of the Fourth Amendment, it requires an oath or affirmation as well as probable cause. And because the Stored Communications Act is attempting to bypass the Fourth Amendment, it is unconstitutional without an oath or an affirmation in place.
A constitutional bypass of the Fourth Amendment must meet all of the requirements set by the Fourth Amendment as well.
The lack of an affidavit blatantly shows that the government has violated some aspect of the Fourth Amendment. Furthermore, in Jones, this court held that a month was a prolonged period of time. However, in today's case, there was information collected for 127 days.
Yes, but Counselor, this information was all retrieved at one time. And the Stored Communications Act allows us to get data for up to 180 days. So is there a constitutional difference over the government action lasting a long period of time versus, oh, I just went and got this one time from this company?
Your Honor, not only would, there is, in application, no constitutional difference. However, in the view from a citizen, the ability of a police officer and of a police organization to be able to retroactively look at your life for 180 days is extremely unnerving. There was also a seizure of Timothy Carpenter's property. The seizing of documents that track Timothy Carpenter 127 days is unconstitutional under the Fourth Amendment.
Justice Brandeis, in his analysis of the Fourth Amendment, said, "It is not the breaking of his doors and the rummaging of his drawers that constitutes the essence of the offense, but it is the invasion of his indefeasible right of personal security, personal liberty, and private property, where that right has never been forfeited." And this court held in Riley v. United States that it is vital to safeguard a sphere of individual privacy in which people can conduct their affairs free of unwarranted government intrusion. However, in today's case, not only did the government conduct a warrantless search, they also seized private documents and interfered with Timothy Carpenter's property.
Okay, I'm having a little trouble with Timothy Carpenter having a proprietary interest in records that the phone company generated and that the phone company was in possession of. How did Carpenter have a proprietary interest in those records?
According to Dickman versus CIR, Your Honor, a person need not possess all of the bundle of sticks of property rights in order to have a protected interest in a location or thing. Timothy Carpenter possessed a right to his papers, and that right was violated. Under the Telecommunications Act of 1996, cell phone users are entitled and able to control and limit what their cell site location information is used for. And the Act further allows that cell phone user the right to exclude other parties from gaining unwarranted access to the same information.
In addition to this, the Federal Communication Commission, or the FCC, has determined that papers containing cell phone site location information are the customer's record, which in turn give the customer full reign on what they choose to do with that information. By gaining access to these papers that rightfully belong to Timothy Carpenter, the federal government seized records without a warrant.
Yes, but in this case, the Stored Communications Act came after this Telecommunications Act. Didn't Congress know that they were in part overturning something that had come previously?
Your Honor, the Telecommunications Act does not directly conflict with the Stored Communications Act. The Stored Communications Act is merely a way for the government to bypass the Fourth Amendment, whereas the Telecommunications Act dictates that it is the property of the person the property of the person is their records obtained by the cell phone company.
Thank you.
In the event that this court does choose to rule that the procurement of cell site location information data is not a violation of the Fourth Amendment, there will be a burden applied to future cases of this nature.
As society and technology adapts, cell site location information will get more precise, and although it is within 50 feet for this case, technology will make citizens more vulnerable to the tactics of the federal government. Riley versus California describes cell phones as such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude that they were an important feature of human anatomy. Today, over 95% of Americans have at least one cell phone, which enables them to be tracked by the federal government. With the expansion of cell site location information data, these small cell locations could potentially track cell phone users down to a location within 10 meters of where they are.
But since cell phone usage is so ubiquitous in our society, doesn't that imply that people are aware that they're being tracked and thus have no reasonable expectation of privacy in their location?
No, Your Honor, there's nothing to suggest that everyone who owns a cell phone knows that the government at any point can collect their cell phone site location information data for a period of up to 180 days. Therefore, by obtaining records, they are not gaining the consent of the customer who owns a cell phone.
The future of cell site location information gives the government the power to spy on anyone, and the mere awareness that the government may be watching still chills associational and expressive freedoms. United States versus Jones, forcing citizens to choose between being regular members of society or having privacy.
The state claimed that because the magistrate judges issued court orders for disclosure under the Stored Communications Act, the warrant requirement of the Fourth Amendment was fulfilled. However, there are a few issues with this contention. First, the Stored Communications Act and the court orders for disclosure do not present the same requirements as a true warrant. Therefore, because the warrant requirement was not fulfilled, it would constitute a violation of the Fourth Amendment.
What's the constitutional difference between reasonable grounds, which the Stored Communications Act requires, and probable cause, which the Fourth Amendment requires?
The constitutional difference does not necessarily come directly from the standards themselves, but rather from what is being looked for and the requirements under the Stored Communications Act versus the requirements of a warrant. What is being looked for in the Stored Communications Act is information that might be relevant to an ongoing criminal investigation, whereas a warrant requires probable cause to show that a crime has been or will be committed. This is a different standard and something different to be looked for, and the Stored Communications Act would open the doors of even wider than they have already been opened to allow somebody who has a basic connection with another person to be trapped up to 180 days because their cell site information data might have something to do with this ongoing criminal investigation.
Your Honor, even if the court orders for disclosure do fulfill the warrant requirement of the Fourth Amendment, the magistrate judges have erred in issuing the warrant, as the section of the Stored Communications Act that states the court must quash a request when the information or records requested are unusually voluminous in nature.
In addition, Your Honor, going back to the first point, due to the nature of the content, there were very few obstacles put in place for the government to go through in order to have access to these records. The only burden that would be placed upon officers is gaining access to these records would be to obtain a search warrant, because there is no way for an officer to know in advance whether a suspect's cell site location information will reveal more or less precise location information, thus necessitating the protection of a warrant according to Kylo versus United States.
The only way for the search to be reasonable would happen with a warrant. The American Civil Liberties Union, or the ACLU, states in their amicus brief that this court's more recent precedent dictates that the government cannot capitalize on new technology to shrink privacy, which is why cases like United States versus Smith and Miller versus United States don't hold as much weight as other cases, due to the fact that they were decided in a society where technology was not as prevalent or necessary to carrying out everyday functions. Therefore, due to the nature and sensitivity of this information, along with the unreasonable length of this tracking, the government's actions in today's case constitute a search under the Fourth Amendment.
Your Honor, even if the warrant requirement of the Fourth Amendment is fulfilled by the Stored Communications Act, the requirements to obtain a court order for disclosure under that act were not met, as the impartial magistrate abused their discretion in allowing the FBI to obtain overly voluminous information. The Stored Communications Act states that a court issuing an order pursuant to this section may quash or modify such order if the information or records requested are unusually voluminous in nature. This shows that the legislature, in enacting this law, had an interest in limiting the amount of information that might be obtained through this quasi-warrant.
Further, the Fourth Amendment protects people within the jurisdiction of the United States from unreasonable searches and seizures. This shows that the framers had an interest in the reasonability of the proposed searches that they were allowing warrants in. However, the judges in the case before the court have allowed 127 days of backlogs to be pulled without a true warrant, essentially allowing a person to be retroactively searched.
But didn't Congress, in passing the Stored Communications Act, set an upper limit of 180 days? And since this 127 days is within that 180 days, it's statutorily not overly voluminous according to the Act itself.
Your Honor, this statement of overly voluminous is another issue that we have with the Stored Communications Act. It is unconstitutionally vague. There is no direct definition of overly voluminous. And Your Honor, what the courts have allowed to happen in today's case is analogous to the injustices that James Otis spoke about in his arguments made against writs of assistance in February of 1761. These writs of assistance were unilateral warrants of a court that allowed an officer of the law to go into a home and search for any and all smuggled material. James Otis stated that these writs of assistance went against the rights guaranteed to the people of Britain by British common law. This was at a time moving towards the line that separated the end of the American colonies and the beginning of America. Our courts have allowed something to happen that even the British government questioned at the height of its tyrannical treatment of the 13 colonies.
The Bill of Rights and the Fourth Amendment in particular carries with it the importance to the founding fathers of personal privacy. In fact, this undercurrent was identified in a way that only justice is able to by Associate Justice Louis D. Brandeis, when he said the makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of the rights, and the right most valued by civilized men.
To allow the government to so erroneously enter into the personal matters of a singular person without a valid warrant, and without even fulfilling the requirements of a quasi-warrant properly, is to go against what Justice Brandeis contends is the most comprehensive of rights, and the most valued by civilized men. This right that was solidified within the Fourth Amendment and the Constitution as a whole through the Bill of Rights, the right to be let alone.
As a last line of defense, the state attempts to use the third-party doctrine, stating that this precludes all aspects of the Fourth Amendment. However, for the third-party doctrine to apply in the case before the court, the state must show that the information obtained by the police did not carry with it a reasonable expectation of privacy.
In order to determine if someone has a reasonable expectation of privacy according to Katz v. United States, you must show two things. First, that a person has exhibited an actual subjective expectation of privacy, and second, that the expectation be one that society is prepared to recognize as reasonable.
First, Mr. Carpenter has exhibited an actual expectation of privacy. This section requires nothing more than an analysis of Mr. Carpenter's actions to determine if he felt that the information that was obtained would have been protected. In this instance, it would be fairly simple to determine that Mr. Carpenter's actions, from bringing this lawsuit to keeping his phone on, are indicative of a feeling that he was safe in carrying his phone with him. Therefore, Mr. Carpenter did have a subjective expectation of privacy.
Second, Mr. Carpenter must show that society is prepared to recognize that expectation of privacy as reasonable. In order to determine the reasonability of Mr. Carpenter's expectation, we must look to previous cases that have allowed a Fourth Amendment issue to be raised. Specifically, we look to United States v. Jones, where a GPS tracking device was attached to Jones's car as he was tracked. In Jones, the court held that people do possess a reasonable expectation of privacy, even through public thoroughfares. This would show that society is willing to accept that people do have a reasonable expectation of privacy, that they will not be tracked.
Further than just the precedent set in cases like Jones, the time span involved in this specific case, as well as the nature of the documents created, what we would consider to be an expectation of privacy that society is willing to recognize. This is because the time period is so vast and it is not a current search. Federal agents were allowed to backtrack into a person's personal phone records without obtaining a warrant for 127 days, obtaining upwards of 12,500 points of data, and that was only pertaining to Mr. Carpenter.
This is an outrageous amount of data for a court to allow to be obtained without a proper warrant, and possibly with a proper warrant being issued. It is because of the sheer amount of retroactive data that was obtained that we contend society would be ready and willing to recognize Mr. Carpenter's expectation of privacy as reasonable.
Moreover, the third-party doctrine relies on a separate legal concept for the determination of the reasonable expectation of privacy. That concept is consent. The truth of the matter is that much like a large percentage of the American population, Mr. Carpenter was unaware that he was being tracked every time he called someone. Many people are unaware of the fact that location information your phone produces as a result of electronic communication is stored, and that the location information will continue to be produced even when your location services are disabled.
Mr. Carpenter also could not have adequately consented to his record of his location because, again, he was unaware that that piece of information was being tracked. Further than that, Mr. Carpenter did not initiate each of the instances in which he was being tracked. That the information that was seized was done so involuntarily, unlike in Miller, where Miller initiated each and every transaction and was aware through his credit records that he was being tracked. Mr. Carpenter did not initiate each and every one of the events that caused his location to be tracked.
If Mr. Carpenter ever received a text message or a phone call, his phone would be sending his location to the phone company and forcing him to be tracked against his will and consent. Therefore, Mr. Carpenter could not have adequately consented to the third party receiving this information.
Your Honors, in summation, the state relies on an overly restricted view of the Fourth Amendment combined with the application of a law that intends to bypass the amendment in its entirety, and a concept that bases itself on the consent of an individual to make their case.
However, we have shown, first, that the view of the Fourth Amendment that the state would like to push is incorrect, and that cell site location information and cell phone data are covered under the Fourth Amendment.
Second, that the Stored Communications Act serves no purpose other than to bypass the Fourth Amendment by creating an even lighter standard than the existing warrant requirement.
And further, we have shown that the records erred in allowing the police to obtain 127 days of location information even under this lighter standard.
Finally, we have shown that the third-party doctrine cannot apply in today's case, as the third-party doctrine is based on consent that was not freely given in the case before the court today.
It is for the reasons previously stated that we pray this court refuse to allow the government to use the Stored Communications Act to bypass the Fourth Amendment, and to rule in favor of Mr. Carpenter, the petitioner in today's case.
Thank
Thank you.